distinguished members both on the dais and off. Alexander Hamilton, one of the founding fathers of the United States Constitution, once said in the Federalist Papers, Federalist number 78, that the judiciary was the least dangerous branch of government among the three great branches of government. Whereas the legislature had the sword and the executive had the purse, the judiciary hath only judgment. Today's debate will really focus around how that judgment is to be exercised and the parameters within which the debate will focus range from whether the first part of Article 142 merely consists of an inherent power. Is it something more than a mere inherent power? And of course, ultimately, does it go to the extent of being a constitutional power of a different quality altogether, which can and indeed must, if complete justice is to be done, bend and if necessary, ignore substantive law. The first draft article 118, which was introduced into the Constitution by the founding fathers, made a very important departure in three important respects from the 1935 Government of India. First and foremost, the Supreme Court was given the power to actually enforce its own judgments and decrees, something the federal court didn't have. The federal court under section 209 of the Government of India could only hand down a declaratory verdict which would then be enforced by the appellate court from which that verdict finally came up in appeal. That was departure number one, which finds its way into the second part of Article 142(1). Departure number two is the departure with which we are really concerned, which is the expression complete justice, because the court may, in exercise of its jurisdiction, do complete justice in any cause or matter before it. Does the expression complete justice, therefore, mean something by which the judicial department can transgress into the other departments and say that, look, on the facts of a given case, I find that justice will not be subserved if a provision of substantive law is to be applied. Is it possible for the court to do that? Is the important debate around which most of us will speak. The Supreme Court, unfortunately, has not spoken in one voice. In fact, it has spoken in four distinct voices. Flip-flop, flip-flop. The first interesting and instructive decision is a Constitution bench decision in Premchand Garg versus Commissioner, which is reported in 1963, Supplement 1 SCR 885. There the question was as to whether an order for security of costs, which could be given in the exercise of the discretionary jurisdiction under Article 32, was something which would affect the core of the fundamental right under 32 itself. This, of course, was laid down by a legislative rule under Article 145. The rule was struck down by a majority of the court, and the court specifically held that 142 cannot be utilized in order to in any manner transgress any constitutional provision. But in saying so, it also went on to say, indeed, in order to strengthen its argument, indeed, it cannot even transgress any substantive law. The maximum that it can do is to bend certain procedural laws because it happens to be an apex court. This was the state of the law and continued to be such until we arrive at the famous Antule decision. Now, in Antule, a 7-judge bench expressly affirmed Premchand Garg's case and laid down that a substantive provision, namely Section 7(1) of the Criminal Law Amendment Act in that case, could not possibly be transgressed by the Supreme Court in any ultimate molding of relief that it may do under 142. And therefore, since a very valuable right had been taken away to be tried by a special judge alone, an order transferring the matter from a special judge to a high court would be bad and would also sound in constitutional impropriety because it would also violate the petitioner's rights under 14 and 21. Now, when 7 judges expressly therefore affirmed Premchand Garg, one would have thought that the matter stood settled and the controversy was over. Far from it. In 3 years' time, the dissenting judge in Antule's case, there was only one dissent by the junior-most member at that point of time, Justice Venkatachalayan. The dissenting judge in the famous Union Carbide case somehow came to a startlingly different result. What he did in that judgment was, and there were many very interesting questions of far-reaching importance raised, we are really concerned with only 2 of them. The first question really that was raised in Carbide with which we are concerned is whether the court had a power to withdraw to itself first, in the exercise of its jurisdiction under 142, all civil and criminal cases which were filed all over the country because of the Bhopal gas leak disaster to itself. Question 1. And question 2 as a corollary, in giving effect to a settlement arrived at, could it thereafter quash criminal prosecutions under 142? Both questions were answered in the affirmative. The first question was answered in the affirmative by reasonably simple reasoning, which was that 142 really is meant in order that procedure does not override the substantive rights of parties, so that therefore there be no real difficulty in transferring to yourself everything, even though it may be outside the express terms of Article 139 capital A, which in any case is a subsequent addition to the original constitution. And there would be no difficulty therefore in bringing to yourself all these cases, a perfectly reasonable view. But then you come to step number 2, and this is where the rub lies. In step 2, the learned judge examined the argument that Premchand Garg had in fact been approved by Antule, which was a bench of 7, but somehow came to the conclusion that both Garg and Antule were judgments which involved constitutional limitations as opposed to statutory inhibitions, and therefore somehow sidestepped Garg and Antule, which in my respectful submission it was not possible to do, and then came to the result that Article 142 was a power which transcended ordinary statutory power, and since it transcended ordinary statutory power, unless there was an express prohibition in substantive statutory law, the Supreme Court was free as a knight errant to roam at will under Article 142. Now, the law didn't stop here, but further developed and along another interesting line, because there was a judgment in Vinay Chandra Mishra's case where, apart from sentencing an advocate to contempt of court and a certain sentence and fine, 6 weeks in jail, the court went further and suspended his license. And the question therefore directly arose, could you do that under your power, under Article 142? And the whole question was regurgitated again. This time the Supreme Court came around to sidestepping Carbide. You will remember now, Carbide unfortunately sidestepped both Antule and Premchand Garg. Yet another 5-judge bench now sidesteps Carbide and says that Carbide did not actually say that you could ignore substantive law. That's the first mistake in my respectful submission that the court made. Carbide said exactly that. Carbide said, short of an express statutory prohibition, it was open to you under 142 to ignore substantive law. That was the point of Carbide. Otherwise, Carbide would have been differently decided. The point in Carbide was that, look, you had 3 sections of the Criminal Procedure Code staring you in the face. You couldn't, therefore, if Premchand Garg was right, bend or twist them in any manner. And the answer given by Carbide was, sorry, I can. And I will do so, but of course on facts ultimately I find that since a proper case for withdrawal was not made out, we will not in our discretion ultimately quash the criminal prosecution. But the whole problem has been from the beginning that instead of cleanly either following or overruling decisions, at each stage the Supreme Court and various constitution benches have just sidestepped the other. Now finally you come to 2 other judgments, and this now is flip, flop, flip. We've reached flip. There's another flop coming up, and that flop is in 2 other slightly more recent judgments after the Supreme Court Bar Association judgment was handed down. The first is again a constitution bench speaking for 5 in Somaya Organics, which is a judgment reported in 2001. Now there the issue again squarely raised by counsel was that, look, you may utilize 142 to mold relief but nothing more. You can't say that prospective overruling, which is something our constitution didn't recognize until Golaknath came in, and Golaknath also recognized it not exactly by a majority because you had 5 against 5 with the 6th judge saying nothing. The major problem with prospective overruling was that when it came to a law which transgressed a fundamental right, Article 13 stared you in the face. So that the moment you declared that particular law void, straight away without more, it was void from the very inception. That's what Article 13.2 says, plainly. How then is it possible for you to say, look, an earlier judgment wrongly construed the law, said that it did not transgress the fundamental right, which we are overruling today, but that we will give effect to our judgment only from today. That we will give effect to our judgment only from today flies in the face of Article 13. And that was the argument expressly recorded. The judges didn't actually get over it. All they said was, 142 is there to mold relief, we are molding relief without more. That was not correct. They were doing much, much more. They were ignoring a substantive provision of the Constitution. Now comes the second, other case, which again makes a departure from the Supreme Court Advocates on Record Association case of 98. And that is the famous judgment in Ashok Hura, the 2002 decision, again handed down by a constitution bench. Article 137, read with the Supreme Court rules, clearly states a second review is not permissible under any circumstance. This judgment lays down, again flying in the face of 137, because 137 specifically says, subject not only to a law made by Parliament, but by rules made by the Supreme Court under 145, a review is permissible. And the rule says no second review. Despite that, the court under 142 somehow founds in reality a second review, which it calls a clarificatory petition on 2 very, very narrow, 2 extremely narrow grounds. Now, this again, in my respectful submission, would not be directly possible for the reason that there is a direct constitutional inhibition staring you in the face. That inhibition cannot be got round merely by using some other phrase, because ultimately, after a first review is dismissed, a second review would then lie under this particular decision on a ground that I did not know at that time that, let us say, the judge was biased. One of the grounds. The other was that you are not served at all, and therefore natural justice was breached. But that would then go to the very first ground of review itself, which is found in the rules. The discovery of a new matter which goes to the root, which you could not with reasonable due diligence discover earlier. And that you are permitted to do only once. If you have missed the bus once, you can't do it again. So the trouble is that from Premchand Garg downwards, and by this time we have covered 5 constitution bench decisions. Each one has spoken in different voices. Let us now, having examined the constitution benches on the subject, go to some of the articles of the constitution itself and see which possible view emerges from a reading of some of the conjoint articles. Now, if we start from Article 131, you will find that 131 invests an original jurisdiction in the Supreme Court to decide cases or controversies which arise between the Union and the states or between states themselves. Could it possibly be suggested that in the exercise of this original jurisdiction, in order to do complete justice to one state, you could ignore substantive provisions? Obviously it couldn't. So when it comes to the exercise of an original jurisdiction, or let us say an appellate jurisdiction as of right, as you have under Articles 132 to 134, when, for example, a High Court certifies that a substantial question of law arises, then again, it would not be possible, because this is now an appeal as a matter of right. It has to be heard under the law as it stands. And it would not therefore be possible in doing complete justice to one party at the cost of the other to turn around and say, look, I feel that this particular statutory provision is not an express prohibition. Since it's not an express prohibition, I need not apply it under my power. Now, 142 itself speaks of the Supreme Court acting in the exercise of its jurisdiction. That jurisdiction may be original, it may be appellate. The content of the power doesn't change when the jurisdiction is original and suddenly change when it becomes appellate, and that too a discretionary appellate under 136. Because it is only when you come to Article 136 that there is this discretion now given to the court at both stages in the appeal, whether before the grant of special leave or after the grant of special leave, either to interfere or not to interfere. And since it's an extraordinary appeal, in fact, the language of 136 begins with a non-obstant clause, making it clear that it is not now covered by any of the former provisions. There is no substantive right of appeal. This is an extraordinary situation which needs to be righted. And in that extraordinary situation, the court may well say, all right, I find the situation extraordinary, I wish to write it. It may turn around and say, I don't find the situation extraordinary, I don't wish to write it, despite the fact that there may have been a wrong. So 142 can't be made to depend upon whether you have the original and or appellate jurisdiction as a matter of right on the one hand, and an appellate jurisdiction as a matter of discretion on the other. This is the first point. The second interesting point that arises is, you have a number of other articles giving you little clues to this power. Take Article 140 for example. 140 speaks of incidental powers being given to the Supreme Court by Parliament by law. Now, the article expressly says, though I don't think it is necessary, that this has to be subject to the other provisions of the Constitution. So one thing is clear, therefore, that this power to do complete justice is cannot possibly be assimilated with an incidental power. Now, if it is not an incidental power, the argument that it is a mere inherent power must necessarily go without more. So now we reach a stage where it is something more than an inherent power. Now, what is this something more? If we look at certain other articles, for example, Article 138 and 139, by which Parliament by law may further invest the Supreme Court with not just jurisdiction but powers as well. with regard to matters covered by list 1, for example, or invests Parliament, or Parliament invests the Supreme Court by law with the power to issue high prerogative writs for purposes other than enforcing fundamental rights, which are 138 and 139. Obviously, therefore, the 142 power cannot be used, for example, to issue a writ without this parliamentary law for purposes other than the enforcement of fundamental rights by the Supreme Court. For example, a habeas corpus of a father against, let us say, any family member, asking that family member to be brought to the court. The state here is not involved. So therefore, we find that when we actually see the facilis of articles all around 142, we get a slightly clearer picture, and that picture appears to be this. The picture is that whereas you may never ignore a substantive statutory provision for the very simple and basic reason that if you ignore it, you are in fact doing injustice to the party in whose provision, in whose favor that provision exists. So that you cannot then say that you can ignore this substantive provision, but at the same time what you can say is that look, this is a final court. Since it's a final court, and we are final though not infallible, but ultimately we are final, we must do complete justice. The emphasis in my submission really is on the word complete, which I don't think anybody has really examined so far. The idea is to set at an end all controversy by bending procedural laws if necessary, and mind you, only those procedural laws which do not vest some substantive right in a person, but laws which are plain matters of procedure, to ultimately arrive at a just result, provided, however, you do not step upon any substantive statutory provision. In Martin Burns' case, a 1966 judgment, Justice Sarkar had very beautifully put it when he said that there is nothing like an evil flowing from a statutory provision. Either the statutory provision stands, in which case it has to be obeyed whether the judge likes it or not, because ultimately rights are determined in accordance with the statutory provision, and that really goes down to a very, very fundamental thing, the doctrine of separation of powers. Because laws ultimately are made by the legislature which are meant to be followed in every case. It can't be that suddenly you arrive at an apex court. Down the line they are all meant to be followed. One person may ultimately arrive at the apex court, another may not. But suddenly when you arrive at the apex court, you have a power which is almost despotic in nature, which says that look, so long as there is no express prohibition, that's good enough for me. I will do complete justice according to my likes and not according to what the statute prescribes. It flies in the face of what we understand as a separation of powers. And therefore I would like to end only by saying that it seems to me that 142 ought to be left to be as flexible as possible in order to ultimately mold relief and do complete justice, but without transgressing the law in any manner, because justice according to law is part and parcel of the rule of law which the Constitution is all about. Thank you very much.